Recording in progress.
Good morning, honorable members. Welcome to the meeting. Just in terms of who's currently on the platform, we have Honorable Mikolakis, Honorable Maleka, Honorable Ndongeni, Honorable Badenors. Yeah, okay, and we have an apology from Honorable Mtetwa, Honorable Dango, in terms of so the other members who are not on the platform, yeah, I'm sure they would be joining us. Oh yes, and Honorable Bartlett would also be joining us. Apparently her airplane, she's on a flight which had just landed now, so she said she would join us. That being said, members, just in terms of today's proceedings, we expecting to receive we're expecting to receive responses by the Department of Correctional Services on the public submissions on the Correctional Services Amendment Bill. And thereafter, we would be getting a briefing on 3 bills by the Department of Justice and Constitutional Development, the Divorce Amendment Bill, the I'll just term it the RICA Amendment Bill, and then the Cannabis for private purposes bill. But yeah, so just that's just in terms of our proceedings. Let me then also take this opportunity, because I see the Deputy Minister for Justice and Constitutional Development is also on the platform. Let me also take this opportunity to welcome him. And to welcome the legal teams from both the Department of Justice and Correctional Services and from the Department of Correctional Services rather. Welcome all. That being said, honorable members, just in terms of the Correctional Services Amendment Bill, we received a briefing on this bill on the 18th of October 2023. Thereafter, the bill was advertised for comment, for public comment from the 27th of October to the 10th of November. Our members would have received the submissions that we received. There were a total of 3. there were 2 individuals and 1 organization, Just Detention International, that made public inputs in this process. The individual submissions were largely general in nature, whilst the organization submission was more specific. Members would have also received a document from the department also outlining their responses to these comments. But we will also formally receive the department's response, and I will then hand over to the Department of Correctional Services to take us then through the public responses. I see Mr. Mukulubete, are you going to take us through?
Good day, Chairperson.
Good morning, Chair. I'll be doing the cannabis bill instead. Thank you.
Oh, okay. Am I mixing departments? I'm so sorry.
Apologies, Chair. Mr. Van Wyk will be doing the DCS.
Oh, yes, Mr. Van Wyk. All right, I see that. All right. Mr. Van Wyk, over to you, sir.
Good morning, Chairperson. Good morning, members of the Select Committee. It's Mr. Zigarada speaking for now. We are together with Jack Van Wyk. We are sending the apology for the National Commissioner who is in another engagement. It was an emergency engagement. He will try to log in. With that, I will hand over to Jack, Mr. Van Wyk, to take us through the presentation, and we are also projecting it. Miss Andronica Mabunda will be projecting, and Jack will do the presentation. Thank you very much, Chairperson.
Good morning, Honourable Chair, Honourable members, colleagues. I'm Jack Van Wyk. Thank you for the opportunity. I'm from Legal Services National Office, Correctional Services. Am I audible?
Yes, you are. Please continue.
Thank you, Chair. Yes, Honourable Chair, we've received 3 public submissions. One from Luyema Ngozo, another from Kosinati Kabuza, and from Just Detention International South Africa. I'm going to kick off by addressing the submissions we received. On the document on the screen, you will note in the middle column is space for comments. This is just a summary of what the commentators has or have submitted. With regards to Luyema and Ngozo, the submissions we received is not related to the bill. However, we did note those comments from the commentator, mainly about the issues surrounding victims, victim empowerment support, victim information that must be on record, more involvement by DCS through its social workers with the families and of inmates to perform interventions and establish more halfway houses for parolees. Our response to that, Honourable Chair, is that although it's not relevant to this bill, it is definitely incorporated in the general review of the Correctional Services Act, which we are in the process with. So those inputs are definitely appreciated, and it's very important for DCS to receive such information and comments. And we have definitely noted that, and it's included in the general review process of the CSA, which we are currently busy with. If I can move on to the following commentator, Kosinati Kabuza. The same issue here, if I can go to the second page. Thank you, Mrs. Mabunda. Second page, please. In any case, with regards to the comments received from Gabuza, they are also not related to the bill itself. The commentator refers to skills development of inmates to be strengthened and encouraged, ensure that people convicted of violent crimes receive, in inverted commas, tough sentences, and strengthen victim offender dialogue programs. Insofar as it relates to the Correctional Services Act, we have noted that and appreciate these comments. And also, as with the first commentator's comments and inputs and submissions, we submit that it's also forming part of the general review of the CSA insofar as it is applicable to the Correctional Services Act. So on that score, there's not much regarding this bill to respond to. Then the last submissions that we received, the last submission we received was from Just Detention International South Africa. And we referred to section, or they referred to section 95D, clause 6.1 of the bill. And obviously for that matter to the definitions clause, where they propose that sexual violations be replaced by sexual offences in the definition 6 section. We also dealt with this at the National Assembly at the Portfolio Committee, and it was agreed that it will also form part of the general review of the Correctional Services Act. And that has already been inserted in the discussion document. With regards to the use of non-binary pronouns, referring to, his and hers, to replace that with they. It's our submission that his and hers, with regards to this Correctional Service Amendment Bill, only appears once. It appears at clause 4E, and it refers to the inspecting judge. So therefore, it will not be possible to refer to they or to change it to they. We submit. But in general, generally speaking, that's also noted with appreciation, and it has also been, it's also forming part of the general review of the Correctional Services Act, not just to change those areas where, where his and hers are used. We're replacing it with they and them, but also to make the act more user-friendly and move to a plain language principle with regards to the Correctional Services Act. But for the purposes of this bill, and as highlighted in our previous engagements, the purpose of this bill, the object of this bill, is to comply with the judgment, in the main, to comply with the judgment of the Constitutional Court, especially with regards to the impugned sections 88 capital A1B and section 91. Yes, and this is our submission in principle to the submissions received, and we submit accordingly. Thank you for the opportunity, Honorable Chair. Thank you.
Thank you very much, Mr. Van Wyk and Mr. Zikalala. Members, there we have it. As indicated, the comments that's before us, but most issues raised, obviously as presented, will add value to the general review of the Correctional Services Act. That being said, honourable members, do you have any questions or comment that you would want to make based on this presentation? Okay, I'm not seeing any hand. Just in general, honourable members, I think in our previous engagement when the bill was prepared, was presented to us, I think one of the issues that did come up in that discussion was around the urgency for the ministry to obviously introduce the Judicial Inspectorate for Correctional Services Bill. I think that still stands. But is there any other comment that members would want to make? If not, honourable members will then continue processing this bill in our next meeting and possibly look into the committee report around that matter. That being said, all members, we'll move then to the to the second agenda item, which is in relation to the presentation or the briefing, sorry, that we would get by the Department of Justice and Constitutional Development on the Divorce Amendment Bill. Let me then take this opportunity as well. Oh yes. Maybe just briefly on members, just to indicate that the Divorce Amendment Bill amends the Divorce Act 70 of 1979 to give effect to the Constitutional Court judgment in Women's Legal Center Trust versus the President of the Republic of South Africa and others. And maybe also to indicate on members that the Constitutional Court deadline on this bill is the 28th of June 2024. I think that being said, Deputy Minister, let me then hand over to yourselves to take us through this presentation. DM.
Thanks, Chair, and good morning to you and all honourable members. The officials from the department, I'm not sure whether it will be Ms. Buerta will be doing the presentation. I can't see Ms. Pillay, but Mr. Sebelemecha is here, so he then, if in the absence of Ms. Pillay, would be the leader of the officials. But just to say, so there will be a presentation, and whoever is presenting it, if they can flight it. Maybe just to say by way of background, the problem is that, or the harm the amendments are trying to address is that many Muslim couples have marriages in terms of Islamic law, but then did not get them registered with Home Affairs or did not have a civil marriage at the same time. So the law of the country effectively recognized them as outside the marital system or the legal system for marriages. That then resulted in a number of problems when there were divorces, in that particularly the women could be left destitute and then had to approach the courts for assistance. The court had then basically, ultimately the Constitutional Court had said both the Marriage Act needed to be amended to provide for Muslim marriages to be recognized as marriages, but also the Divorce Act needed to be amended to include Muslim marriages as marriages that a civil divorce could be obtained. And the bill basically follows the order of the Constitutional Court in that regard. Just to say that the bill does not amend Sharia law. All it does is provide that couples who, or a person who was in a, or is in a Muslim marriage can approach the civil courts, that would be the regional courts or the High Court, for a divorce. So that the Divorce Act can apply to them. But the bill does not deal with Sharia at all. It's a bit like if you are Roman Catholic, you can't get divorced in terms of, as far as I understand, in terms of the position of the church. However, you can get a civil divorce, which is then legally recognized. So that's the background for the bill. Home Affairs is bill is a bit late because Home Affairs is preparing a omnibus marriages bill, which also includes divorce. But we've realized that this bill will not be passed in time, and as there isn't a reading in provision in the judgment, these amendments that the court wanted need to be affected. So that is what this bill is doing. and it will be pending a broader redoing of the entire marriage and divorce regime. So I just wanted to give that by way of background. Oh yes, in the National Assembly, the bill was supported by all parties. The bill wasn't amended in the National Assembly at all. The bill was supported by all parties, with the exception of Al-Jamaa, who seemed to think that, Mr. Hendricks, the member there, seemed to think that because Home Affairs is now providing or registering historical Muslim marriages, that it was no longer necessary. However, persons who don't have their marriages registered would still be at risk, and this bill is necessary for them, because I think we know as South Africans that not everybody does what they're meant to do in terms of having a marriage registered. So, Chair, with those introductory remarks, if I can hand over to Advocate Sebela, or Chief Director Sebela Mecha, to lead the presentation or indicate who's going to do it from the department side. Thanks, Chair.
Good morning, Honorable Chair and members, and as well as the Deputy Minister. Ms. Pillay is available. She's online, although the presentation will be made by Ms. Alison Botha if the Chair permits. Thank you.
Okay, Ms. Botha, please continue.
Thanks, Chair. Can I just check if my screen is visible? I'll move to slideshare mode. Is that visible? And am I audible?
Yes, it's visible and you are audible.
Thanks, Chair. I'll jump straight into it. This is the presentation on the Divorce Amendment Bill. Good morning to you, Chair, and the members. Thank you to the DM for the introductory remarks. With that in mind, let me move straight into this presentation on the Divorce Amendment Bill. We'll be going through the purpose, the background of the bill, and then finally a discussion and a clause-by-clause analysis of the bill. The background of the bill lies squarely in the Constitutional Court judgment in the WLCT case, which was handed down in 2022. And that case recognized the need for and the importance of protecting Muslim women and children of Muslim marriages on the dissolution of the Muslim marriage. The case stems from 3 separate applications which were brought in the High Court and then consolidated. And that High Court judgment was then taken on appeal to the SCA and subsequently to the Con Court for confirmation. The Con Court held that the Divorce Act was unconstitutional to the extent that it failed to recognize Muslim marriages, which have not been registered as civil marriages, as valid marriages. So the Con Court held that the Divorce Act was inconsistent with sections 9, 10, 28.2, and 34 of the Constitution, and those provide for, respectively, equality, dignity, best interests of the child, and access to courts. The Con Court held that sections 6, 7.3, and 9.1 of the Divorce Act were specifically declared to be unconstitutional. The WLCT judgment then the Con Court went on to suspend the declaration of constitutional invalidity for a period of 24 months from the date of the order to enable the President and Cabinet, together with Parliament, to remedy the defects by amending existing legislation within that time. The Con Court did specify interim measures which will operate pending the coming into force of the amended Divorce Act, but the Con Court did not read in an order, so the bill is necessary and urgent and it must come into force before the suspended declaration of invalidity and interim measures lapse. So the bill must come into force by 28 June 2024. The Con Court also held in the WLCT judgment that the Marriage Act 1961 is unconstitutional to the extent that it fails to recognize Muslim marriages which haven't been registered as civil marriages as valid marriages. The Department of Home Affairs, which administers the Marriage Act, has the same deadline of 28 June 2024 to remedy the defects to the Marriage Act through amendment or through the introduction and passing of new legislation. The Department and the Department of Home Affairs have been engaging extensively on the Department of Home Affairs' proposed marriage bill to align timeframes and policy approaches insofar as possible between the marriage bill and this bill. But it's now apparent that the parallel timing of the marriage bill and the divorce amendment bill is not possible, given the early rising of Parliament next year due to the elections results in a shortened time for Parliament to process bills. The WLCT judgment is a departure from the current position. Currently, Muslim couples who choose to marry according to Islamic law or Sharia law can only rely on the provisions of the Divorce Act if they also conclude and register a civil marriage in terms of the Marriage Act. The bill seeks to amend the Divorce Act in order to address the issues in the WLCT case. The bill aims to provide a recognition of and protection for Muslim women and children of Muslim marriages on the dissolution of a Muslim marriage. The bill will not require the separate civil registration of a Muslim marriage in order for the parties to a Muslim marriage to rely on the provisions of the Divorce Act, thereby recognizing the validity of a Muslim marriages for a purpose of civil divorce. On to a clause-by-clause discussion of the bill. Clause 1 defines a Muslim marriage, and it's as broad and all-encompassing as possible to avoid prescribing a detailed definition of the Muslim religion, which may not be accepted by all adherents of Islam, and it also provides legal certainty for interpretation. Clause 2 amends Section 3 of the Divorce Act, which provides for the dissolution of a marriage and the grounds for divorce. And it provides that now a Muslim marriage may also be dissolved by a decree of divorce. Essentially, it extends the application of the Divorce Act to Muslim marriages. Clause 3 amends Section 6.1 and 6.3 of the Divorce Act, which provides for the safeguarding of interests of minor and dependent children. And that extends the safeguarding of interests of minor and dependent children of a marriage to now also include minor and dependent children of a Muslim marriage. And it addresses the WLCT order that Section 6 of the Divorce Act is unconstitutional because it fails to safeguard the interests of minor or dependent children of Muslim marriages in the same manner as children of other marriages on dissolution. Clause 4 amends Section 7 of the Divorce Act, which provides for the division of assets and for the maintenance of parties. It provides for the insertion of a new subsection 3A, and that extends the application of the section to Muslim marriages. It also extends the application of subsections 4, 5, and 6 to the new subsection 3A, and it extends the factors which the court must take into account when deciding an application for the redistribution of assets in respect of a marriage out of community of property, to include any contract or agreement between the parties in a Muslim marriage where the husband is a spouse in more than one Muslim marriage. This amendment addresses the order in the WLCT case, which held that Section 7.3 of the Divorce Act is unconstitutional because it fails to provide for the redistribution of assets on the dissolution of a Muslim marriage. And the amendment in Clause 4D follows the consideration of an interim measure in the WLCT order. Clause 5 of the bill amends Section 9 of the Divorce Act, which provides that the court may order the forfeiture of patrimonial benefits when a divorce is granted on the grounds of irretrievable breakdown of a marriage. It extends its application now to include a Muslim marriage, and this was amended to address the order of the Constitutional Court in the WLCT case, which held that Section 9.1 of the Divorce Act is unconstitutional as it fails to provide for the forfeiture of patrimonial benefits on the dissolution of a Muslim marriage in the same terms as other dissolved marriages. Clause 6 of the bill provides for the application of the bill to all subsisting Muslim marriages, including a Muslim marriage which was terminated or dissolved in accordance with the tenets of Islam, and where legal proceedings for the dissolution of the said Muslim marriage in terms of the Divorce Act have been instituted but not yet finalized, and which subsisted as at 15 December 2014. This clause was introduced as a result of the interim measures specified in the WLCT case. Clause 6A seeks to protect Muslim women whose Muslim marriages were dissolved only in terms of the tenets of Islam, but in respect of which proceedings were instituted in terms of the Divorce Act for a civil dissolution. Clause 6B seeks to protect Muslim women whose Muslim marriages subsisted as at 15 December 2014 by providing for the application of the Divorce Act to those marriages. The retrospective application of this clause is limited to balance the rights and interests of Muslim women and children and third parties, and to limit potential unintended consequences. And Clause 7 is the short title of the bill. Brings me to the end of the presentation on the Divorce Amendment Bill. Thank you, Chair.
Yeah, thank you very much, DM and the team from the department for the presentation. Our members, do you have any questions for clarity that you would want to ask and or comment that you would want to make? Okay, no, if there's none, our members, obviously we would continue processing this bill, but we will also proceed to publish the bill for public comments, and I think at a future time, we will then further deliberate on this bill as well as on any comments that we receive on this bill. Gershwin, can you just give me an indication if my bandwidth is better?
Yeah, good day, Chair. Yes, it is, Chairperson.
Okay, that's fine. I was made to understand that I was breaking a bit earlier. Our members will then move to the next agenda item, which is the third one with regard to the regulation of the interception of communications and provision of communication-related information amendment bill, also known as the RICA bill. The proposed amendments, our members, to the RICA bill seeks to give effect to the 2021 Constitutional Court judgment in the Amabongani Center for Investigative Journalism and another versus the Minister of Justice and Correctional Services and others, which had declared certain sections of RICA unconstitutional. The Concord suspended the declaration of unconstitutionality for 3 years to give Parliament sufficient time to amend the RICA to address the constitutional defects. And once again, the deadline is the 3rd of February 2024. In the interim, the provisions read in by the Constitutional Court, sections 23A and sections 25A form part of the RICA until Parliament enacts legislation to that effect. Let me once again hand over to yourself, Honourable Deputy Minister, to once again take us through this bill, this amendment.
Thanks, Chair. I'll just make some introductory remarks and then hand over to DDG Pillay, who is on the platform to lead the department's presentation. But basically, the background is that the department had wanted to do a complete overhaul of the regulation of the Interception of Communications Act. And in fact, in the case, the minister had asked for 3 years, not the normal 2, which was granted. However, things did not work out in terms of pressures that the section of the department was under with COVID, with a senior official passing away and other senior officials, one in particular who was working on the bill, becoming unwell. So the broader program for overhauling RICA had to be temporarily abandoned to focus on these amendments, which the officials will take you through. However, the minister is still committed to the overhaul of RICA, and the officials can also give you a report on how far that process is in terms of asking for submissions by government departments, and then there will be broader consultation. So this is a short-term measure until that overhaul can take place. Generally, in the public hearings, the complaints were that the bill should be addressing broader issues. The whole issue of records obtained under Section 205 of the Criminal Procedure Act subpoenas and the lack of safeguards for that. The DA speaker in the House yesterday raised issues with the registration of SIM cards, which is definitely something that is not working as well as it should be. But all those issues we're saying would be part of the broader review that would be taking place. In the National Assembly, there was one amendment made, which was that RICA currently provides for the possibility of more than one designated judge being appointed. The bill is introduced, specified that it was only one. So that was amended in the National Assembly to revert to the position that is currently in RICA. But if I can then hand it over to DDG Pillay and to go through the bill and how it responds to the court order. Thanks, Chair.
Thank you, Chairperson. We have prepared a presentation, and if you wish, I can speak to the what we are doing on the overhaul of RICA, the complete overhaul of RICA. If not, I will hand over to Ms. Porter to take us through the presentation.
Ms. Pillay, I'm sure members would want to know about that process on the complete overhaul, but perhaps you could come in after on that, and let's get the presentation on the amendments.
Thank you, Chairperson. I'll hand over to Ms. Porter. Thank you.
Thanks, Chair. I'll just switch to slideshow mode. There we go. So this is the presentation on the RICA Amendment Bill. Let me jump straight into it. We're going through the purpose, the background of the bill, and then a clause-by-clause discussion of the bill. Thank you to the DM for his introductory comments, and it is correct that this bill lies squarely in the Amabungane judgment, which the Constitutional Court handed down on the 4th of Feb 2021. The Concord confirmed the declaration by the High Court of South Africa, Gauteng Division, Pretoria, that RICA is unconstitutional to the extent that it fails to provide adequate safeguards to protect the right to privacy, as buttressed by the rights of access to courts, freedom of expression and the media, and legal privilege. The Concord declared RICA to be unconstitutional to the extent that it fails to provide for safeguards to ensure that a judge designated in terms of Section 1 of RICA is sufficiently independent, to provide for notifying the subject of surveillance of his or her surveillance as soon as notification can be given without jeopardizing the purpose of surveillance after surveillance has been terminated, to adequately provide safeguards to address the fact that directions are sought and obtained ex parte, to adequately prescribe procedures to ensure that data obtained pursuant to the interception of communications is managed lawfully and not used or interfered with unlawfully, including prescribing procedures to be followed for examining, copying, sharing, sorting through, using, storing, or destroying the data, and to provide adequate safeguards where the subject of surveillance is a practicing lawyer or journalist. The ConCourt suspended the declaration of unconstitutionality for 36 months to afford Parliament an opportunity to cure the defects causing the invalidity. ConCourt granted interim relief by way of reading in of certain provisions to RICA, which provisions on the disclosure that the person in respect of whom a direction, extension of a direction, or entry warrant is sought is a journalist or practicing lawyer, and post-surveillance notification, and those will operate for the duration of the suspension. An amendment to RICA is therefore required to address the defects within the set deadline of 36 months, that is, by 4th of Feb 2024. The discussion of the bill. This bill seeks to amend RICA to address the issues decided in the Amabungani case, that is, the notification issue, the independence issue and designated judge, the ex parte issue, the management of information issue, and the journalists and practicing lawyers issue. It inserts certain definitions, provides for the designation of an independent designated and review judges, provides for the powers and functions of the review judge, provides for the tenure of designated and review judges, provides for adequate safeguards where the subject of surveillance is a journalist or practicing lawyer, provides for post-surveillance notification, provides for adequate safeguards to address the fact that interception directions are sought and obtained ex parte, provides for adequate procedures to ensure that data obtained pursuant to the interception of communications is managed lawfully and not used or interfered with unlawfully, provides procedures to be followed for processing, examining, copying, sharing, disclosing, sorting through, using, storing, or destroying of any data, provides for principles for the safeguarding of data when dealing with the management of data, and provides for matters connected therewith. Now on to a clause-by-clause discussion of the bill. Clause 1 amends Section 1 of RICA by amending the definition of designated judge and now includes definitions of prescribe, review judge, and this act. Clause 2 inserts Chapter 2A and inserts Clause 15A to 15D in RICA. Clause 15A provides for the designation of a designated judge. The Minister must designate a designated judge in consultation with the Chief Justice by notice in the Gazette. That designated judge must perform all the functions conferred upon them independently and without fear, favour, or prejudice. Further provides that a designated judge is required to, in respect of an application in terms of sections 16, 17, 18, 19, 20, 21, or 22, within 5 days of a decision to issue an order, judgment, direction, entry warrant, deferral order, declaratory order, subpoena, notice, or other process, refer the information or documentation considered in arriving at the decision, together with a copy of the decision, to the review judge. It also requires a designated judge to, in respect of an application in terms of Section 23, after issuing a direction or entry warrant under subsection 3, or for an oral direction or an oral entry warrant under subsection 7, and for a decision under subsection 11, to immediately refer a copy of the decision to the review judge. Clause 15A further makes provision for the immediate implementation of the decision by a designated judge, pending the review thereof by the review judge in terms of Section 15C1. Clause 15B provides for the designation of a review judge. The Minister must designate a review judge in consultation with the Chief Justice by notice in the Gazette. The review judge must perform all the functions conferred upon them independently and without fear, favour, or prejudice. Clause 15C provides for the powers and functions of the review judge, and it provides, inter alia, that the judge must, in respect of an application in terms of Section 16, 17, 18, 19, 20, 21, or 22, within 5 days of the receipt of the information or documentation considered by the designated judge and the copy of the decision of the designated judge, consider and either confirm, vary, or set aside the decision of the designated judge. Clause 15C further requires the review judge to, in respect of an application in terms of Section 23, to confirm, vary, or set aside any decision of a designated judge immediately or as soon as practicable upon receipt of the decision. The clause further requires that the decisions of the review judge must be delivered to the designated judge, who must then in turn inform the applicant of the decision of the review judge. This clause also provides that any decision by the review judge must be executed immediately upon receipt thereof by the applicant. Further, the review judge must keep a record of the exercise of any power and the performance of any function. Clause 15D provides for the tenure of the designated and review judges, and it provides for a non-renewable period not exceeding 7 years and for the termination of that tenure. Clause 3 inserts Clause 23A in RECA, and it provides that when a person in respect of whom a direction, extension of a direction, or entry warrant is sought is a journalist or practicing lawyer, then an application to a designated judge must disclose that fact, that the intended subject of surveillance is a journalist or practicing lawyer, and the designated judge may impose conditions necessary to protect the confidentiality of a journalist's source, or in the case of a practicing lawyer, to protect the legal professional privilege enjoyed by his or her clients. Clause 4 inserts Clause 25A in RECA. Section 25A1 provides that within 90 days of the date of expiry of a direction or extension issued in terms of Section 7, 8, 16, 17, 18, 19, 20, 21, or 23 of RECA, the person who was the subject of the direction must be notified in writing of such direction. The applicant that obtained the direction, or if not available, any other law enforcement officer within the law enforcement agency concerned, must notify in writing the person who was the subject of the direction, and within 15 days of doing so, certify in writing to a designated judge, judge of a high court, regional court magistrate, or magistrate that the person has been so notified. Section 25A2 provides for the withholding of the notification on 2 bases. First, jeopardizing the purpose of the surveillance, and 2, the potential to negatively impact on national security. The former allows for a designated judge, judge of a high court, regional court magistrate, or magistrate, on application to direct that the notification be withheld for a period which must not exceed 90 days at a time or 2 years in aggregate. The latter allows for a designated judge on application to direct that notification may be withheld for a period as the designated judge may determine. Clause 5 amends Section 35 of RECA by deleting paragraphs F and G of subsection 1. And these paragraphs deal with prescribing information to be kept by the head of an interception center and the manner in and the period for which such information must be kept. Clause 6 amends Section 37(1) of RECA by providing that the head of an interception center must keep or cause to be kept proper records of such information as may be prescribed. Clause 7 inserts Clause 37A in RECA to provide that the procedures to be followed for the processing, examining, copying, sharing, disclosing, sorting through, using, storing, or destroying of any data obtained pursuant to and resulting from the interception of communications in terms of RECA and any other act must be in the prescribed manner and on the prescribed conditions. It also provides for the principles that must be taken into account regarding the management of data, such as inter alia, accountability, processing limitations, purpose-specific processing of data, conditions for the storage of data, and security safeguards. Clause 8 inserts Clause 62D in RECA to provide that the Minister may make regulations. Any regulation made which may result in the expenditure of state monies must be made in consultation with the Minister of Finance, or any regulation which has a bearing on any designated or reviewed judge must be made in consultation with the Chief Justice. Clause 9 provides for the laws amended and provides in the schedule for the amendment of Section 3 of the Intelligence Services Oversight Act 1994. by the substitution in paragraph A for subparagraph 3. The amendment provides for the review judge to submit a report regarding his or her functions, together with any comments or recommendations which such review judge may deem appropriate, provided that such report shall not disclose any information contained in an application or direction referred to in that act. Clause 10 provides for transitional measures. It provides that any judge whose designation prior to the commencement of the bill is still in force will remain in force for 5 years from the date of commencement of the bill. It provides that any order, judgment, direction, entry warrant, deferral order, declaratory order, oral direction, oral entry warrant, subpoena, notice, or other process issued or made prior to the commencement of the bill, which is still in force on the date of commencement of the bill, must be regarded as having been issued under the bill and remains in force until the period or extended period for which that order, judgment, direction, entry warrant, deferral order, declaratory order, oral direction, oral entry warrant, subpoena, notice, or other process was issued or made lapses. All pending matters must further be dealt with in terms of the bill. Clause 11 amends the arrangement of section by including the new clauses provided for in the bill, and Clause 12 contains the short title and date of commencement. And that brings me to the end of the presentation on the RICO Amendment Bill. Thank you, Chair.
Thank you very much, Ms. Botha. Ms. Pillay, would you also want to take us through in terms of the complete or the comprehensive reform of RICO?
Yes, thank you, Chairperson. We have started a process of consultation. Firstly, we've started with government entities, and we sent out a request for inputs on the issues that they would like to see amended. And the closing date was the 27th of October, which we extended slightly to the 3rd of November. But some major inputs are yet to be submitted, and we are doing a follow-up letter on that. But the long and short of it is that by June next year, we hope to submit a draft bill to Cabinet for the consultation process to commence. So over and above consulting with the state entities, we also will be consulting with the private sector entities. And in fact, the Minister has already started a process of discussion with the network service providers regarding the issue of SIM cards. And so I think those processes will dovetail. And but at the end of it, I think the overall due date is to submit a bill to Cabinet for consultation in June next year. Because Chairperson, this is it's a highly technical matter, but also quite complex. And we will be meeting we will stick to our deadlines as proposed, because we've given us sufficient time for the discussions to ensue and to draft a bill, and then thereafter take it to Cabinet and introduce in Parliament. So may I ask if Mr. Sibela Mecha would like to add, because he will be leading the process from the department together with me.
Thank you, Chair and Ms. Pillay. I think I've captured or covered everything. The process basically will also include the research, which we will be concluding at the end of March 2024, and thereafter we'll be developing a bill, which, as indicated by Ms. Pillay, will take it to Cabinet by June. So we have already started doing research and the framework of our own internal timelines, wherein we have timed the processes or steps to be followed against the deadline of July, upon which we'll have to approach Cabinet. Thank you.
Okay, thank you very much, Deputy Minister and the entire team for that presentation. Members, there we have it. The amendment bill is intended as an interim measure to address the defects as identified by the Constitutional Court. and as indicated now that the comprehensive reform of RICA is underway in terms of consultations, etc. And obviously this would be a matter for the next term parliament to deal with. Honourable members, do you have any questions for clarity on this the presentation? Okay, if not, I take it that honourable members are happy and comfortable for now. But obviously, we will proceed to publish the bill for public comment, and we will obviously continue with our deliberation on the bill, taking it further. Okay, thank you very much on this item. Honourable members, we'll then move on to the last agenda item, which is on the Cannabis for Private Purposes Bill. This bill creates a new legal framework to govern cannabis for private use by adults and alternative means to deal with children and cannabis use. This is in line with the Constitution 1996 and the Constitutional Court judgments handed down in Prince and the Centre for Child Law in 2018 and 2022, respectively. That being said, let me then hand over to yourself, Deputy Minister, once again, to take us through. Thank you.
Thanks, Chair. This bill, the other two bills are quite recent. This bill is, I think, until yesterday, the sixth oldest bill in the National Assembly. So it was introduced in 2020, and it's been around for some time. The Prince judgment had its 5-year anniversary a few months ago. Luckily, the court had done a reading in, so there was no gap. But one of the important things to note with the use of cannabis for private use has been decriminalized for the last 5 years. And I think it's important to note that the skies have not fallen. Anyway, the bill was introduced. The problem with the bill is it was initially trying to just comply with the Constitutional Court judgment, which was decriminalizing the use of cannabis for private use in a private or not in a public place and by adults. It should have come with other legislation dealing with the regulation of the growing of cannabis for commercial purposes, but it unfortunately didn't. The Portfolio Committee, I think, had 3 public hearings on the bill. The first was trying to expand the bill to meet the concerns from a range of other stakeholders, Rastafarians, and other groupings. But then that had actually gone too wide. Then a further public input was needed with the Centre for Child Law judgment on the fact that children in possession of cannabis shouldn't be, in possession or using cannabis shouldn't be criminalized. But the bill that you have before you then was effectively rewritten. It's a bill as presented by the Portfolio Committee, not as amended. The bill does then comply with the judgment. It does do things like limit the definition of cannabis to the tops of the plant, the flowering bits, which is where the THC is. It still criminalizes dealing in cannabis, which is exchanging cannabis for reward. That is also what the Constitutional Court did. The idea is that there would be opportunities through a permit system to regulate that, but that would come later. Surprisingly, because it's such a complex and diverse issue, the bill. There is broader consensus, as I understand it, on the bill from many of the stakeholders in the cannabis sector. In the National Assembly, the bill was supported by everyone except the Freedom Front Plus and the ACDP. So I think, having said that by way of introduction, if I can hand over to DDG Pillay to lead on the presentation. Thanks, Chair.
Thank you, Chairperson. May I introduce the team that will take us through it?
Please continue, Ms. Pillay.
Thank you, Honorable Chair. Mr. Makulubeta will take us through the presentation. We have two members on this team. It's Mr. Dupriya and Mr. Makulubeta. May I hand over to Mr. Makulubeta, who I see is starting to share his screen. Thank you.
Yeah, just before Mr. Makulubeta starts, because the two officials have worked so extensively on the bill, privately we were calling them Mr. Maruwana Makulubete and Mr. Hemp Dupriya, not Henk. That's just by way of a side note. Mr. Makulubete, over to you.
Thank you, Deputy Minister. Good morning to yourself, Chair, and the honorable members. I just want to find out if I'm audible and if my presentation can be seen on the screen.
You're audible, Mr. Makulubete, but your presentation just needs to go into presentation mode.
Thank you, Chair. I will do that.
Okay, it's fine. Please continue.
Yes. Thank you very much, Chair. Chair, as the Deputy Minister has indicated, this bill flows from the judgment in Prince, where the Constitutional Court has essentially declared Section 4B and the Section 5B of the Drugs and Drug Trafficking Act, as well as Section 22A9A Roman Figure 1 of the Medicines Act to be unconstitutional on the premise that they decriminalize the use or possession of cannabis by an adult for an adult personal consumption in private, and this essentially, according to the Constitutional Court, was in violation of the right to privacy. As a result, Chair, the court, as it normally does in most instances, suspended the order of invalidity for a period of 12 months up until the 17th of September 2020, so as to give Parliament an opportunity to correct the constitutional defect in the Drugs Act and the Medicines Act. And the court granted an interim relief by way of a reading in, so as to ensure, Chair, that during the period of suspension of invalidity, it will not be a criminal offense for an adult person to firstly use or be in possession of cannabis for his or her personal consumption in private, and secondly, to cultivate cannabis in private place for his or her personal consumption in private. Chair, as the matters stand, the Drugs Act and the Medicines Act essentially has the effect or have the effect of prohibiting a commercial production of hemp. As a result, the Department of Agriculture has requested that the amendments be effected so as to provide for the commercial production of hemp. However, as Justice Department, this is not the turf of the department to commercialize hemp or cannabis, and it is left for other departments to deal with this. So the bill will be focusing only on responding to the Constitutional Court judgment in Prince, and also in this judgment, the Center for Child Law, in which the Constitutional Court declared Section 4B of the Drugs Act to be inconsistent with the Constitution, and invalid to the extent that it criminalizes the use or possession of cannabis by a child. Chair, in terms of that judgment, it cannot be said that imposing criminal sanction on a child creates a legal framework for the protection of the child. Channeling a child through the criminal justice system as opposed to social justice systems designed to protect children can essentially lead to exacerbated harm and risk for the child concerned. Cannabis use is a social problem, Chair, and an appropriate response which recognizes the child's right in Section 28 of the Constitution should be located in social systems as opposed to the criminal justice system. So essentially, Chair, the court was of the view that the child should not be processed like an adult through the criminal justice system. The court further reiterated the need for a social response to cannabis use or possession by a child and concluded that the response should be wholly centered on rehabilitation, support, recognizing the inherent vulnerability of the child, and as such, Chair, the response should not be located within the criminal justice system. As a result, Chair, the court made several orders, including the suspension of the constitutional invalidity for 24 months up until the 28th of September 2024 for Parliament to finalize the legislative reform process. And Chair, instead of having the reading in this judgment, the court instead put a moratorium to say that during the period of suspension, no child may be arrested and or prosecuted and or diverted for contravention of Section 4B of the Drugs Act, insofar as it criminalizes the use and or possession of cannabis by a child. Furthermore, the court ordered that a child apprehended for the use or possession of cannabis may be referred to civil processes, as I've mentioned, instead of being processed through the criminal justice system. Furthermore, the court ordered for the expungement of criminal records for the children, and this must be by way of an application to the Director General. In terms of the bill itself, the use and possession of for personal use of cannabis by children is no longer criminalized. The important thing is to emphasize that the dealing or getting other children to deal in cannabis is the mostly important aspect of the bill that needs to be criminalized in respect of children. Further, Chair, the bill contains several clauses which criminalizes certain conduct, one of which is dealing in cannabis, that is contained in clause 4.1 of the bill. The possession in a private or public place of cannabis in excess of the maximum amount prescribed for private purpose. Essentially, Chair, the minister will, by way of regulation, prescribe the maximum amount of a possession of cannabis. Thirdly, Chair, the cultivation of cannabis plants in excess of the maximum number prescribed. The regulation will cover that. Engaging a child by an adult or another child to deal in cannabis is also criminalized. The transportation of cannabis in an amount exceeding the maximum amount prescribed for private purpose, or in contravention of or for failure to comply with a certain prescribed condition, restriction, prohibition, obligation, requirement, or standard, or even the use of cannabis in a vehicle on a public road. So the minister will also prescribe the regulation to cover this aspect. Also, Chair, it discriminalizes the use of cannabis in public. Also, the use of cannabis in a private place, but in the presence of non-consenting adults or children is criminalized. The smoking of cannabis within a reasonable distance from a window of or ventilation inlet or doorway to entrance into another place, or where its smoke is likely to cause a disturbance or nuisance to any person is also criminalized. The bill aims to respect the right to privacy of an adult person to use or possess cannabis. It also aims to regulate the use or possession of cannabis by an adult person. Importantly, as contained in the Center for Child Law Judgment, to provide for an alternative manner by which to address the issue of the use, possession, or dealing in cannabis by children with due regard to the best interest of the child. It also aims to prohibit the dealing in cannabis, provides for the expungement of criminal records, and it also amends certain laws. Chair, in the first instance, as a bill will normally have, the bill contains the definitions as contained in clause 1.1. Clause 1.2, Chair, is very important because it is intended to make an offenses contained in clauses 4.1, 4.4, and 4.5 inapplicable to activities that are expressly authorized in the bill or in terms of a permit or a license issued under any other legislation. Chair, currently there are licenses or permits that are issued in terms of the medicines and the Plant Improvement Act. So these should not be affected. That is, the licenses and the permits issued under or in terms of those pieces of legislation should not be affected by the provisions of the bill. Clause 2, Chair, recognizes the right to privacy of an adult person to use and possess cannabis and to cultivate cannabis plants as contemplated essentially in the Prince Judgment. In terms of Clause 2.1, an adult person may provide to or even obtain from another adult person cannabis in a private place for a private purpose, but this must be without the exchange of consideration. Essentially, Chair, whenever there is exchange of consideration, there will be dealing, as the Deputy Minister has mentioned in his introduction. Dealing is a very serious problem in the country, and we are intending, in terms of the bill, to prohibit that. The further clause, being clause 2.2, prohibits an adult from using cannabis in a private place for a private purpose in the presence of a child or non-consenting adult person, or within a reasonable distance from a window of or ventilation inlet, doorway to entrance into another place, or that forms part of any public place where persons congregate within close proximity of one another, or where the smoke of such cannabis is likely to cause disturbance or a nuisance to any person at that place. Chair, the adult use, in terms of clause 2.3, an adult person may possess cannabis in a public place, but they cannot use such cannabis in a public place. The next clause is intended to protect children against the adverse effects of cannabis in consideration of the best interest of the child principle. Chair, it is important to note that the bill does not give the children the right to use, possess, or cultivate cannabis, and does not also criminalize use, possession, or cultivation by children either. However, in instances where a child is found to have contravened any legislation that regulate cannabis, the bill contemplates that such child must be dealt with outside the criminal justice system as directed by the court, in the Center for Child Law Judgment. Instead, the child share must be dealt with in terms of the Children's Act, the Prevention of and Treatment of Substance Abuse Act, or any other relevant legislation. The dealing in cannabis chair is recognized by the bill as a very serious offense, and a child found dealing in cannabis must be dealt with in terms of legislation that I have referred to, that is the Children's Act or the Prevention of and Treatment of Substance Abuse Act, or even the Child Justice Act. Chair, the bill prohibits adult person from permitting a child to use or possess cannabis, or to supply a child with cannabis or a product containing cannabis. However, Chair, a responsible adult is permitted to administer cannabis to a child with or without the consent or knowledge of that child if prescribed by a medical practitioner. Clause 3.3 obliges an adult person who is in possession of cannabis to take reasonable measures of ensuring that such cannabis is inaccessible to a child, whether that child is under the authority, supervision, or care of that adult person or not. Chair, to engage a child to deal in cannabis is prohibited in terms of clause 3.4. Clause 4 provides for the offenses and penalties which a court may impose for the contraventions of the provisions of the bill. These penalties, Chair, are dependent on the nature of the offense in question, and they may be in the form of a fine not exceeding 2,000, or imprisonment for a period not exceeding 12 months, 5 years, or even 10 years. Chair, the penalty that may be imposed not exceeding 12 months or both to that period of imprisonment or a fine are essentially in relation to the conduct of permitting a child to use or possess cannabis, providing or administering a cannabis to a child unless prescribed by a medical practitioner. So for these conducts, Chair, there could be a penalty of a period not exceeding 12 months. Chair, this is the maximum penalty that may be imposed in terms of imprisonment, and it can be that period of imprisonment or even a fine or both. Chair, the penalties that may be imposed for up to a fine of 2,000 in relation to the conduct by an adult person for being in possession of cannabis at any place and failing to store such cannabis in a secure space that is inaccessible to a child. Furthermore, Chair, transportation of cannabis and contravening or failing to comply with any condition, restriction, prohibition, obligation, requirement, or standard regarding the transportation of such cannabis as may be prescribed by the minister through the regulations. Using cannabis in a vehicle on a public road can attract a fine of up to 2,000 rand. As a passenger, Chair, in a vehicle on a public road for contravening or failing to comply with any condition, restriction, prohibition, obligation, requirement, or standard regarding the transportation of cannabis that may be prescribed by the minister in respect of such passenger. And also, Chair, the use of cannabis in a public place can attract a fine of up to 2,000 rand. Also, using cannabis in a private place in the immediate presence of a child or non-consenting adult person. And finally, Chair, smoking cannabis in a private place within a reasonable distance from a window of, ventilation inlet of, doorway to, or entrance into another place, or forming part of any public place where persons congregate within close proximity of one another, and where the smoke is likely to cause a disturbance or nuisance to any person at that place. Chair, the penalties for imprisonment of up to 5 years, or both imprisonment and a fine, relate to the conduct contained in the bill. One being in possession of cannabis, either in private or public place, in an amount which exceeds the maximum amount prescribed for private purpose. The minister is going to prescribe this. Cultivating cannabis plants in excess of the prescribed numbers. Transportation in excess of the maximum amount that will be prescribed also attracts a 5-year prison term. 10-year prison term can be imposed on its own or in addition to a fine for the following conduct, 2 of them being dealing in cannabis and engaging a child to deal in cannabis. Chair, the important thing that I have to mention at this stage is as contained in clause 412, which provides that a penalty imposed for payment of a fine without an alternative of imprisonment does not constitute a previous conviction as contemplated in the Criminal Procedure Act. Essentially, Chair, if you are fined, then you do not earn a previous conviction for that. Chair, the further clause, in clause 5, provides for the expungement of criminal records for the convictions in relation to essentially the repealed pieces of legislation that were applicable in the TVBC states and any former self-governing territory. So the bill contemplates that convictions that were made in respect of those pieces of legislation resulting in the criminal records, the bill contemplates that those records can be expunged. Chair, as I've mentioned, the bill provides for the regulations, and these are the items that the minister is going to make regulations in respect of. I have mentioned A and B, but there will be a prescribed form which the minister is going to design, on which a person's written application for expungement of a criminal record must be made. There will also be a regulation to provide for a certificate of expungement that will be issued by the Director General of the department, and also the manner in which the Director General must submit those certificate of expungement to the head of the Criminal Record Center of South African Police Service. Chair, the minister has a discretion also to make regulations to prescribe any matter which is necessary or expedient to achieve the objects of the bill. However, Chair, in relation to paragraph 261A and 262, the regulations that will be made by the minister in respect thereof must be approved by Parliament before they are published in the Gazette. Chair, the bill has a schedule which provides for the amendments to certain pieces of legislation. There's 2 of them, being the Drugs Act, in terms of which in paragraph H, part 2 of the Schedule 2 of the Drugs Act is amended to delete dronabinol, and in part 2, we are deleting cannabis and the tetrahydrocannabinol. Chair, the effect of this will be to remove the entire issue of cannabis from the purview of and scope of the Drugs Act, making way for cannabis to be regulated under its own separate legislation, as this bill does. The second legislation that the bill intends to amend consequentially is the National Road Traffic Act, in terms of which the insertion is made of a definition of a drug having a narcotic effect to mean any substance or combination of substances that have an impairing effect on a person's ability to control his or her action, but excludes THC. Because of this exclusion, Chair, we are inserting a definition of THC as any substance containing trans-delta tetrahydrocannabinol. Chair, there are other sections that are amended. I don't need to go through all of them, but the intention of amending section 15(1)(g) is to provide that a person who is disqualified a person can be disqualified to obtain or hold a learner's or driving license when that person is addicted to the use of any drug having a narcotic effect or the excessive use of intoxicating liquor or THC. Section 61(1)(g) is amended, Chair, to essentially ensure that where a driver is involved in or the conduct of the driver contributes to an accident, that driver must not take any intoxicating liquor or drug having a narcotic effect. We are amending this provision so as to ensure that the person is also prohibited from taking THC in those circumstances. That is where the driver is involved in an accident or the conduct of the driver contributes to an accident. Section 65 is also amended to criminalize the driving of a vehicle or to occupy the driver's seat of a motor vehicle whilst the engine is running on a public road while that person is under the influence of THC or THC in combination with alcohol or a drug having a narcotic effect, or the concentration of THC or drug having a narcotic effect in any specimen of blood or combination of THC, alcohol, or a drug having a narcotic effect in any specimen of blood or breath, which is not less than the concentration that is specified in that act. Section 75 also, Chair, is amended by the insertion of a new section 1A to provide that cabinet member responsible for transport may, in consultation with the cabinet member responsible for health, prescribe any drug or category or class of such drugs having a narcotic effect and the concentration thereof for the purposes of section 65, 10, and 11. Chair, I have indicated that the Prince judgment has put in a reading in. The Deputy Minister has alluded to this, and the amendment should have been effected by the 17th of September 2020. Obviously, then that deadline has passed, as a result of which the reading in that has been put in place by the Constitutional Court has become a final. However, I want to highlight this to the Chair and the committee members that in the judgment that was handed down by the Constitutional Court in 2017, the court held that interim relief to address constitutionally defective legislation coupled with a period within which legislation must be promoted to correct such legislation have the effect that the interim relief continues to apply until it is changed by Parliament. Therefore, Chair, a failure to comply with the deadline that has been set by the Constitutional Court does not bar Parliament to pass this bill, even if the deadline that has been imposed by the Constitutional Court has passed. Chair, this brings me to the conclusion of my presentation, and thank you very much.
Okay, once again, thank you very much, DM and the entire team for the presentation on the on the bill, the Cannabis for Private Purposes bill. Our members, once again, any comments or questions for clarity? Perhaps maybe just one from my side, DM and the team. I think with regard to the clause 4 offences and penalties, you make reference to passengers in respect of transportation of cannabis. But there's no reference made to drivers or owners of the vehicle who possibly bear a bigger responsibility to ensure such transportation is lawful. But then again, also when you go to clause 6, with regard to that the minister must make regulations in respect of etc., but it does refer also to the person transporting cannabis as well as in respect of the passenger in such transport. Yeah, especially with regard to standards. Yeah, no, but maybe clarity in terms of these two issues, DM and the team, or maybe if this is also a drafting omission, we can get an indication on that. Over to yourself, DM.
Chair, if I can ask Mr. Mukulubete to respond, or any of his team.
Okay.
Thank you, Chair. In the presentation and under paragraph 242B, there's a provision for an offense for the transportation of cannabis. This will relate to the driver who is transporting that cannabis. And also in that paragraph, we are making provision for the contravention by that driver to, or failure by that driver to comply with the conditions that are going to be put in place by the minister. So that paragraph B deals with the driver who transport cannabis. And as you have said, Chair, paragraph D deals with the passenger themselves. That is, there will be the regulations put in place by the minister to deal with the conduct of the driver or the passenger in relation to cannabis on a public road, and also the conditions that the passenger will have to comply with on a public road in as far as cannabis is concerned. Yes, indeed, Chair, the regulations are going to be made in terms of clause 6 to stipulate those conditions, and that must be complied with so that the penalties that are imposed by the bill in respect thereof can be known by the public. That is my response to that, Chair. Thank you.
Okay, no, yeah, thank you very much for that response. I think it does clarify the matter. I think if there are no more questions, let me then indicate on members, we will then advertise this bill for public comment, and obviously we would have an opportunity to deliberate further, as well as on the comments that we received on the bill. I think that being said, honourable members, I think we've come to the end of the meeting. Let me thank you, Minister, as well as the legal team from the Department of both Justice and Correctional Services, as well as the legal teams from Parliament who are also present on the platform. Let me also thank honourable members for their attendance to this meeting. I think we've managed to complete this meeting in good time because we do have a plenary in the NCOP at 2, and the fact that we finish at this time will allow members then to make their way to Parliament. Once again, thank you very much. And let me declare this meeting closed.
Thanks, Chair.
Thanks, Chairperson.
Thank you, Chair.